Get ready for the dictation in 3, 2, 1, start. The Supreme Court in Radha Chemicals versus Union of India Civil Appeal number 10386 of 2018 arising out of SLP C number 2334 2018 decided on 10/10/2018, which was an appeal against division bench judgment dismissing the appeal against order of single judge remanding the matter back to arbitrator, finding that point of limitation had not been decided correctly, granted leave, and while referring to earlier decision in Kinnari Malik and another versus Ghanshyam Das Damani 2018 11 SCC 328 reiterated that the court, while deciding a petition under section 34, has no jurisdiction to remand the matter back to arbitrator for a fresh decision and held as under. We therefore set aside both the judgments and relegate the matter to the stage of the original Section 34 petition, which now has to be heard on its merits in accordance with the parameters laid down by this court for decision under Section 34 of the Arbitration and Conciliation Act. Accordingly, we remand the matter to the single judge, who is requested to take up the matter and decide the same at the earliest, considering that the award in this case has been passed over 10 years ago. In view of foregoing discussion, the instant appeal is allowed. The impugned order is set aside and matter is remanded back to learned court below for deciding application of the appellant under section 34 of the act afresh, strictly in accordance with law. The learned court below is also expected to examine the application de novo and decide the same by spelling out reasons for arriving at its conclusions. It is further observed that the learned court below shall examine the application of appellant Union of India under section 34 of the Act afresh, dispassionately, and uninfluenced by any observation made in this order. The learned court below is also requested to decide the same at the earliest, considering that arbitral award in the matter was passed way back on 27th February 2012. The record of the case be sent back to the learned court below forthwith. Costs are made easy. The case at hand calls for attention, intervention, and exercise of plenary powers vested in it by virtue of Article 226 of the Constitution of India. The case, lying in a narrow compass, has a larger socio-culture concern and even larger canvas. The petitioner, known as Ganga Kumari, has been claiming herself to be a person belonging to feminine gender. The petitioner, having acquired requisite educational qualification, vied for the post of constable in the Constable Recruitment 2013, advertised wide notification dated 14/7/2013. The petitioner, after clearing the written examination, successfully underwent physical efficiency test and physical standard test. Her documents and credentials too were found in order, for which her name was shown in the select list published on 13/2/2014 at serial number 148 for the district Jalore. When the petitioner was called for medical test, it transpired that the petitioner is a hermaphrodite, commonly known as unisex of transgender. Such being the medical report, the respondents took their hand off and instead of permitting her to join, they pushed her file in dormancy. The petitioner claims to have roamed from pillar to post in anxiety to serve the police department, for which she sent scores of representations also, but all in vain. Faced with such situation, she knocked at the doors of this court, invoking its extraordinary jurisdiction for the following reliefs: 1. By an appropriate writ, direction, or order, the respondents may kindly be directed to grant appointment to the petitioner on the constable in the category of OBC female in pursuance of select list dated 13/2/2015 forthwith. Stop. Thank you.